Mr. Fitzpatrick, we will just wait a minute until Justice Cowan, I think, is on this panel. You can rehearse your argument while we're waiting.
Well, oh, I'm sorry, Your Honor.
No, it's fine. We're waiting.
Oh, I'm sorry. So I should proceed?
No. I was trying to introduce a note of humor, which I obviously
sorry,
failed.
Sorry. Well, in the interest of engaging in some repartee with the court, I guess I will note my thanks for the. This is the first time I've been in this courtroom, and it is lovely. It's absolutely a lovely change from the old quarters, and I have to say, I truly appreciate the attention to detail, which includes the hand grips on this podium, which are recessed right here. I think that many a counsel is very appreciative of that. I know the old podium, you would sometimes find yourself sort of flailing your arms around trying to get a good grip.
I can't.
I hear high heels.
Yeah.
Mr. Fitzpatrick, please proceed.
Thank you, Your Honor. May it please the Court, Madam Chief Justice, John Fitzpatrick on behalf of the defendant, Kenneth Taylor. There's only one issue before the Court today. That would have to do with whether or not Mr. Taylor, who was tried for first-degree murder, a trial which resulted in a hung jury, whether Mr. Taylor should be put to trial again, not only as a principal in the murder at issue, but also as a joint venturer, that is to say, under a theory of joint venture / felony murder. As the Court is aware, the common law of this Commonwealth, which applies double jeopardy principles as manifested in the Berry versus the Commonwealth case, holds that after a mistrial, a defendant should not be put to trial again in a case in which there was insufficient evidence as a matter of law in the first trial. This is a departure, as both sides acknowledge in this case, from United States Supreme Court precedent, which is now extant, in the aftermath of Richardson versus the United States. Now, one may have some theoretical or analytical quarrel with the Court's holding in Richardson, particularly as that squares with the precedent of Ash versus Swenson. But putting that aside, the present common law of the Commonwealth is such that Berry applies. And my argument in this case has been that under the principles enunciated in Berry, and specifically as seen in cases such as Rodriguez, an appeals court case, which I cite in my brief, and also in the Fickett case, I believe footnote 4 in Fickett, which the Commonwealth highlights in its brief, based upon those, I guess one might say, intuitive or intrinsic principles of fairness which underlie the double jeopardy notion, which has been present in our jurisprudential system for hundreds of years now.
Mr. Fitzpatrick, let me ask you this. As I understand the evidence, there was evidence that your client went with a group of people, was seen entering a building, was seen exiting a building, correct?
Yes, Your Honor.
Someone was murdered, someone was killed.
Yes, Your Honor.
And then a witness said that he made some statements in the car or at some, was he in the car with the witness?
Yes, Your Honor, that is correct, yes.
Car driving away. Made some statements that suggested that he, in fact, had been the person who shot the victim, correct?
Absolutely, Your Honor. Yes, Your Honor.
But that statement from the witness, which was admissible, is not crystal clear. And why isn't this a jury question to decide whether or not your client was, in fact, the perpetrator or part of a group of people who jointly engaged in criminal activity?
Well, I guess, Your Honor, that I might take some issue with the characterization that the statement of the witness in the car, who was the primary Commonwealth witness at trial was less than crystal clear in terms of its import, Your Honor. I don't have the exact verbiage used by the witness here, and I'm not going to take the Court's time up while I flip through my brief to find it. But it's essentially a witness stating that my client, allegedly, and this was, I absolutely agree with what Your Honor said to the extent that Your Honor is suggesting there is a live jury question here, which is to the extent of what did the witness say, is the witness credible, and so on. But more to the point of what I believe Your Honor was saying just a moment ago, I think what she said, this was a witness named Natasha Nelson, who was the key Commonwealth witness at trial. And I think what Ms. Nelson said in substance was, my client allegedly said something to the effect of, my client shot the kid because he was reaching for a phone or something.
No,
And
no, I
they have to
understand that.
believe him.
I'm sorry, Your Honor?
They have to believe her.
Do they have
The
to
jury
believe
have
Ms.
to
Nelson?
believe the
I would hope not,
report.
Your Honor. So I would hope not, and that was my hope, of course, at the initial trial.
If in fact this witness ties him in somehow to this venture, then this whole thing is moot, is it not? Because there's sufficient evidence to go on either theory.
Well, a fortiori, Your Honor, if indeed the witness, as Your Honor says, quite rightly, ties my client to a joint venture, that is absolutely so.
Correct.
I have no quarrel with that, Your Honor.
And I think it's conceded there's enough evidence to convict him as a principal.
Well, as I said before, Justice Giles, in the Superior Court, I would never want to waive any of my client's arguments or rights, but suffice it to say, I don't advance that argument. In other words, I'm not suggesting.
Let me be very more specific. We are here reviewing a ruling of the single justice.
Yes, Your Honor.
The single justice said that a jury may have doubt about the particular detail of Ms. Nelson, is that her name?
Yes, it is, Your
Her
Honor.
testimony. They may find that aspect of her testimony, namely what your client has purported to have said to her, is not credible, or even if they credit her trustworthiness, they may have concern that she misinterpreted the defendant's general description. This is a very frightening set of circumstances. People are running away from the scene of a crime. Somebody has just been shot and killed. Obviously, one of the things that your client or somebody else is saying, don't say anything, don't say anything. In other words, reviewing the single justice's ruling, why is that a clear error of law?
Well, Your Honor, I think that ultimately, of course, this redounds to a judgment call, which I fully understand and appreciate. But I did locate the quote here, Your Honor, because it does seem to be of some significance in this case. And the quote from the witness, and it does bear re-emphasizing, or emphasizing, I guess I should say, that there was essentially no other evidence but this witness's
No, there wasn't
assertion
evidence of people seeing him enter with 2 or 3 other young men into the building?
The same witness, Your Honor. In other words, the witness sees him enter into a building with 3 or 4.
Well, let me propose the closing argument. Assuming that we agree with you,
Yes, Your Honor.
presumably the defense at trial is going to be, he just went into the building. There's not sufficient evidence that he did anything. I mean, this was a witness who may have seen him put something with a black handle into his belt. He may have said something, but can you quite remember? Are you quite sure it was him? Are you certain of the facts? And essentially, if the Commonwealth is left trying to convict your client simply as the principal, aren't you going to argue that there's insufficient evidence to convict him as the principal?
Well,
I mean, if we play it out.
yes, Your Honor, I understand.
I mean, we have a hung jury. We don't know on which. It went to the jury on both principal as the shooter and as a joint venture with other people, correct?
Yes, Your Honor. Yes, I believe so, Your Honor.
And so, so we don't know on what basis the jury was hung, correct?
I haven't a clue, Your Honor. I have no idea.
I mean, they didn't come back and to say we've acquitted him of one and we just can't reach a decision on the other. That would be different, correct?
Yes, Your Honor. My memory of how I argued the case to the jury, and I have certainly, as any of my children will say, I have a very fallible memory, but I believe the way I argued this case to the jury was simply there was an insufficiency of proof as a general matter, and then there were more particular arguments I raised in that regard.
And largely because the witness, the key witness, wasn't in the house, so she didn't witness the murder. All she could tell us about was that people went in and people came out and there was conversation.
Well, exactly so, Your Honor, and that was the nub, I think, of the challenge the Commonwealth faced in the first trial, was that from the time that even if everything that the Commonwealth's prime witness, really only witness in a substantive sense, said was credited, then we have a very elemental scenario where we have her seeing my client, and I think her testimony was 3 other individuals, or a number of other individuals, leave the vehicles, the 2 vehicles in which they arrived at this location. She was emphatic, and I go to some length in my brief to point this out. She was emphatic that there was no hint of any wrongdoing in a sense that we would regard as criminal wrongdoing, short of this party going to this house to purchase some marijuana. And I cross-examined her on this vigorously, and she was emphatic that she saw no hint of anything being remiss.
What is the significance of that?
Well, for example, Your Honor, let us
One
say
of them
that...
had a gun, obviously.
Well...
They're going to buy drugs. Okay, so...
Well, Your Honor, actually, I'm not sure there was any evidence that my client had was brandishing a weapon prior to departing the vehicles.
I may have put you off track. What is the significance of the fact that your witness, who didn't go into the house, didn't know there was going to be a murder and robbery in the house?
Oh, the significance there, Your Honor, is simply that there is no proof of any pre-existing or preconceived plan of any
Except
joint
the
venture.
plan to enter the house by 4 people to buy drugs.
Well,
That's the plan.
it's not. Well, Your Honor, arguably we don't know if that was necessarily a plan. It may very well have only been one person who was going to enter the house, not my client, Your Honor. There could have been 2 people, not my client, who were going to enter the house.
So you're
He went
suggesting
with
that
them.
on retrial, because in your view there was insufficient evidence to convict on joint venture, on retrial, the only theory that the Commonwealth can press is that your client was the shooter.
Exactly, Your Honor. Yes, Your
It
Honor.
seems to me to be a perfect joint venture case, and the only issue is how much of the witness's testimony, the prime witness's testimony, the jury is inclined to believe.
Well, the dilemma
But
there,
if
Your
the-
Honor, is simply that, and again, I apologize, I don't mean to repeat myself, but I just want to make sure it's clearly stated in terms of our position, or my position, which is that there was not sufficient evidence to show that there was any pre-existing joint venture.
Okay, you want us to prohibit the Commonwealth from going to the jury on a joint venture theory, just limit them to principle on
Yes, Your Honor.
retrial.
Yes, Your Honor.
Do you have authority from any other jurisdiction that would support your position that a theory of the case can be barred on a retrial, that this is anything more than a theory?
On that specific point, Your Honor, other than Fickett from this jurisdiction, footnote 4 in Fickett, which I agree with the Commonwealth is dicta, and also the Rodriguez case.
But that...
Well, could I have an answer
That-
to the question
Sure.
first? Do you have any authority from any other
Oh,
jurisdiction?
any other? No,
that-
but none from
that,
any
that
other
a
jurisdiction.
theory, it's not a charge, it's not.
But the Fickett footnote really goes to this point. Is there evidence that cannot be introduced at the second trial? Isn't that, I mean, you're not claiming that there's evidence that she gave, or anybody gave, that should not now be admissible at the second trial, correct?
Well, and again, I apologize to the Court, Your Honor, because my memory is a little faulty. I'm sure I objected to the admission of certain evidence that I would not want to see entered.
No,
into
again,
the
I'm not,
second.
but I mean,
So,
in other
but,
words, if they, you are not saying you can have the same objections at trial, at the second trial that you have at the first trial, but you're not saying that something has happened which now makes it abundantly clear that an appellate court should say this evidence is no longer admissible, correct?
Right. That's correct, Your Honor. I don't think the thrust of my argument is that this is an evidentiary matter. Indeed, the only reason I'm here today, in this case is here today, is that I've been reprising double jeopardy principles throughout this appellate process.
I mean, if you take, I mean, I've looked at the footnote. The footnote, I don't think, it's not the first part of the footnote that's at issue here, although it does say that. It's really, it's the admissibility of it. If, for example, let's say that there was a motion to suppress, the motion was denied, on appeal, we decide that the motion to suppress should have been allowed, you can go back on some, I think this is what Justice Wilkins was saying, you can go back on some other theory, but you can't go back on some other theory now in reliance on what's inadmissible evidence. Isn't it?
Well, the only caveat I would put to that, Your Honor, would be, of course, there are cases, legion of cases, in which this court and the appeals court have found after overruling the denial of a suppression motion that absent the evidence in question, there is not enough evidence to
no, of course, I
carry the case
understand
forward,
that.
and then the case, and then at the appellate level.
But that's a different level. That's an argument up here that says this evidence shouldn't be admissible, Ms. Nelson's testimony, let's say, and once you take that out of the equation, then there is no evidence of joint venture. I mean, first you have to get over, it seems to me what Fickett is saying is, first of all, footnote 4, you have to get over an evidentiary ruling on appeal.
Well, here, I guess what makes, I would argue, makes this case foursquare with the pronouncement in Fickett, again, admittedly dicta, is that, again, we come to the characterization of what evidence there is that a joint venture existed. Because, as I believe Justice Graney had said, if there is sufficient evidence that there was a joint venture, then this whole argument, which I'm pursuing, is moot. And I have attempted to point out in my brief, and obviously for the Court's convenience, I'm not going to recount everything I put in my brief, but that there simply is not sufficient evidence of a joint venture here, for reasons which, again, I will not revisit. And I think I have the yellow light, and if there are no other questions, Your Honor.
Thank you, Mr. Fitzpatrick.
Thank you very much.
Mr. Gladley?
May it please the Court, John Bradley for the Commonwealth.
I don't want to throw you off course, but maybe you might want to begin outlining what the evidence is on joint venture, and because that's the crux of this whole thing, is it not?
It is, Your Honor.
I'm assuming that we decide that we can bar a theory from being presented on a second trial, not just a crime, because don't we first have to reach that issue?
Well, I was about to say my primary argument is that the single justice correctly ruled that there is no authority under the double jeopardy clause to allow a trial judge or a single justice of this Court to dismiss a theory of liability.
No, unless, as Justice Glaney said, there's insufficient evidence to support that. If there's insufficient evidence to support a theory of joint venture, correct?
No, my question is, what authority is there that we could prevent the Commonwealth from proceeding on a theory as apart from a crime? I thought that's the thrust of your whole brief.
That's my primary argument, Your Honor, and there is no authority. I think Mr. Fitzpatrick answered your question in saying he didn't have any authority from any other jurisdiction. There certainly isn't any authority from the cases of this Court or the appeals court to permit such an argument or an avenue of relief.
Well, if a defendant were tried on all three theories of first-degree murder, of deliberate premeditation, felony murder, and extreme atrocity or cruelty, and a jury acquitted him of one of those theories, and if the conviction were reversed, could the Commonwealth then try him again on all three theories of murder? Isn't the Commonwealth barred under principles of double jeopardy from retrying on that type of theory?
Well, I don't know how they could necessarily acquit him of a particular theory, Your Honor. I think on the verdict slip they would check off a box indicating they had based their conviction on a particular theory.
Well, they might say acquitted on extreme atrocity and cruelty, hung on premeditation.
Yeah.
The jury finds that it wasn't extremely atrocious, it wasn't extremely cruel, single shot, whatever, and the jury can't decide whether or not there's sufficient evidence for premeditation. They know there's insufficient evidence for extreme atrocity and cruelty, whoever did it. So they say, we'll get rid of that one, and so they send back the verdict slip. It says, not guilty. Then on premeditation it says, hung, no verdict. You can't go back and try him on extreme atrocity and cruelty, can you?
In those circumstances, Your Honor, I guess I would agree with you. I don't know that I've ever seen that on a verdict slip.
Let me give you a different factual circumstance. The jury is hung. It goes to the jury on premeditation, and it goes to the jury on extreme atrocity and cruelty. And as a matter of law, an appellate court concludes that there was insufficient evidence. Just go along with me. There was insufficient evidence for extreme atrocity and cruelty, i.e., that the jury should not have been instructed on extreme atrocity and cruelty. Okay?
Okay.
That goes to Justice Glaney's question. So once the appellate court has decided there was insufficient evidence, the Commonwealth then can't go. I mean, that seems to me the thrust of the argument. It's not whether it's a theory. The Commonwealth, the defendant is saying there's insufficient evidence here of a joint venture as that has been described in Fickett. It's not footnote 4, it's page 198 of Fickett, which says, we add that there was no evidence that would have warranted a finding beyond a reasonable doubt the defendant shared with the shooter in that case a state of mind that would have justified a finding of his guilt of murder on the theory of joint venture. So once there's an insufficiency of the evidence, I don't think it's a double jeopardy. It's essentially a challenge to the trial judge's ruling that there was sufficient evidence. Isn't there?
I suppose, Your Honor, but here, the only reason we're here is because of the double jeopardy argument.
No, I understand that. I mean, because it's got a double jeopardy nomenclature on it, it comes up now.
Instead of fooling around with the metaphysics of the whole thing, what kind of evidence have you got on
Joint venture.
Well, the evidence is that Mr. Taylor, along with 3 other individuals, 2 of whom were co-defendants in this case, left the 2 cars that were parked on Peckham Avenue in Brockton, were seen by the key witness in this case turning the corner in the direction of the home on 216 Court Street. The door to the 2nd floor apartment was kicked or bashed in. The victim was shot 3 times. One of the upstairs neighbors, upon hearing the gunfire, descends the stairs, literally bumps into a person with a mask from the movie Scream, smells gunpowder in the air, sees the silhouette, if you will, of a gun in that person's hand, and also sees 2 or 3 other people running down the stairs that are wearing dark clothing and hooded sweatshirts. The victim's roommate, who by happenstance was returning home at the time, hears noises and shots coming from inside the building. He sees what he describes as, I believe, 4 people run out the back door. They're wearing dark-colored clothing. At least 2 of them are wearing masks. The others are wearing hooded sweatshirts. The last person out of the building has a gun in his hand. The gun, according to this witness, accidentally discharges in the driveway. They then turn the corner and head back to where the 2 cars are parked on Peckham. That's when they get back in the 2 cars, and the key witness overhears Mr. Taylor make a statement to the effect of, "I hope nobody's got a mouth." They then drive to the apartment of an unidentified female, where Mr. Taylor is alleged to have made additional statements describing why he shot the victim. Specifically, he says he had a phone in his hand. I was afraid he was going to call the police, and so that's why I shot him. I would suggest respectfully that that's overwhelming evidence
of principal liability. But where do you get, what's the evidence that there was any plan, any idea, anything in this defendant's mind when they went in for a shooting or for anything?
Well, if the jury credits the testimony of the key witness, Your Honor, that he was one of the people that ran into the apartment, you have at least 2 people wearing masks. The others are wearing dark clothing and hooded sweatshirts. The door to the apartment is kicked in, and you have the victim shot 3 times. I would submit that that's powerful evidence that he took part in a joint venture to commit an armed home invasion.
Put it this way, Mr. Fitzpatrick, the jury might, Mr. Bradley, the jury might disbelieve the defendant's at least in theory, self-serving statement that the reason why I shot him was because I thought, I mean, if you take out that statement, the reason why I shot him was because he was on the phone and I thought he was going to call the police. If you take out that statement, you may even have a joint venture to go to murder, correct?
That's correct. And that's part of, I guess, my fallback, I don't want to call it a fallback position, but the second part of my argument, that the jury can accept or reject in whole or in part the testimony of any witness, and they could have chosen not to believe that part of that witness's testimony, or simply not found it to be reliable.
Mr. Bradley, the business about I hope no one has a mouth, could you expand on that? That was intended to get all of the participants to agree to conceal this offense?
I think that would be the strong inference, Your Honor. This defendant was alleged to have said that as soon as they get back into the cars, and I think the common sense interpretation would be that he was instructing the others basically not to talk about what happened or else.
Was there any evidence that any of the other co-defendants said, why did you do that? You know, all we wanted to do was go get some marijuana.
The evidence, as I recall it, Your Honor, was that back at the apartment of the unidentified female, co-defendant Joseph Cooper asked the defendant, why did you do that? And that's when the defendant came back with his explanation of he shot the victim because he had the cell phone in his hand, and he was afraid that the victim could call the police.
Well, let me understand this a little bit from another perspective. Your theory is that this is felony murder, and the felony is armed home invasion.
That's right.
With a murder resulting. Let's assume the evidence is sufficient for a jury to decide whether there was a joint venture to commit the armed home invasion, right?
Yes.
Assuming there was enough evidence of that. Doesn't that end it? Does it matter at that point who actually shoots the victim?
I don't think it does, Your Honor. I don't think it does. I think that that's part of my argument that I made in my brief. The evidence, if the key witness were to be believed, would indicate, on all points, would indicate that this defendant was guilty as the principal, as the shooter. But we don't really even have to go that far, as the single justice found, because there was clearly a joint venture to commit an armed home invasion here that resulted in the death of the victim.
So whether you're the shooter or just a participant, you are guilty of felony murder.
That's correct, Your Honor.
Yes, so it's really a sufficiency of the evidence question, although it's come up here under the nomenclature of double jeopardy. It really is the sufficiency of the evidence. Once there's sufficient evidence to submit the joint venture with respect to this defendant to the jury, that's all that's required here, because there's been no acquittal of this defendant with respect to any aspect of the case against him, correct?
That's correct, Your Honor. I think what makes this case unusual is that I have never seen a case, I don't know that there is a case in this Commonwealth where this court has been asked to, on double jeopardy grounds, preclude the Commonwealth from proceeding on a specific theory of guilt. I think that's...
I guess the way to sort it out would be allow them to proceed on the second theory, and then we'll sort it out later if he's convicted on both theories. But, of course, whoever's doing the trial would be smart to have a verdict that separates one from the other.
I'm pretty confident that both sides would request that, Your Honor,
I mean,
on the retrial.
Did the verdict slip, just out of curiosity, specify joint venture principal liability or not?
No.
My memory is that it did, Your Honor.
It did?
I believe so. I believe so.
is there any respect in which you think Fickett, there's any statement in Fickett which is incorrect in any, I mean, I've read Fickett, this case seems to be governed by Fickett, and there's no claim here, or there's no ruling here that there was evidence admitted at the first trial that was improperly admitted.
That's correct, Your Honor.
Okay.
We don't have that here.
So Fickett governs.
Well,
I mean, I don't think that the first half sentence of footnote 4, I don't think stands for the proper. I mean, you've got to read it in the context of an evidentiary ruling.
That's right. The reason I brought it to the court's attention was...
No, it's there.
It's there, right. The only thing I would add, Your Honor, is that Fickett was convicted of, I believe it was first-degree murder. He wasn't here on a double jeopardy claim.
No, that's what I'm saying. Fickett's fine.
Right. And I guess what I would take issue here is that the defendant doesn't have the right to preclude the Commonwealth in these circumstances from proceeding on a particular theory of guilt. And unless there are any other questions, I would rest on my brief.
Thank you, Mr. Bradley.